Dennis Brager. I'm a former IRS trial attorney and a California State Bar certified tax specialist. This is just one in a series of videos designed to give answers to questions that my clients frequently ask. Today, we will be discussing whether or not you should wait to disclose your offshore accounts. In the immortal words of Clint Eastwood, are you feeling lucky? If so, you can just ignore the whole thing. Not something I would advise. Instead, if you are aware that you have unreported financial accounts that expose you to liability for Foreign Bank Account Report or Foreign Tax Compliance Act violations, you should carefully consider the risks of waiting to disclose your offshore account, including the following. The IRS does not have to continue to offer offshore disclosure programs and can change the terms of these programs whenever they wish without any notice. The Offshore Voluntary Disclosure Program or the streamlined filing procedures can be ended at any time. If the terms of the programs are changed, they could be less favorable to taxpayers, resulting in higher fines or stricter eligibility requirements. Second, you are not eligible for offshore disclosure programs if you are currently under IRS examination. This is true even if the examination is for issues completely unrelated to your undisclosed offshore accounts. Once the IRS begins to ask questions and request information from you, you may be put into a very difficult situation if you have foreign accounts that you haven't disclosed, and you won't be able to receive any type of amnesty from these programs. The IRS is increasingly receiving information on foreign financial accounts from foreign banks, which could implicate anyone holding an account with these institutions. If your foreign bank becomes the target of an investigation or works out a deal with the IRS or Department of Justice, you will face an increased offshore penalty of 50% of your aggregate account balances, even when using the OVDP. While the OVDP provides for penalties, these amounts can be calculated with some certainty. If you wait to disclose your account, your potential liability is impossible to calculate. In most cases, you will face civil penalties, which won't exceed $12,450 per violation for non-willful violations, or the greater of $124,588, or 50% of the balance in the account at the time of the violation for willful violations. However, each unreported account can be assigned its own penalty for up to 6 different tax years, resulting in very large potential penalties for some taxpayers. Of course, this doesn't even take into account the possibility of criminal tax penalties, including prison time. An offshore disclosure tax attorney can help you determine your eligibility for the various different disclosure programs and can calculate your anticipated costs for receiving amnesty. With this information, you can then decide whether it's worth it to pay up now, or you can continue to wait and hope the IRS never catches up to your FBAR noncompliance. If you found this video helpful, please let me know by leaving a comment. And if you would like me to update you when I post a new video or send out a newsletter, please send an email to taxhelp@bragertaxlaw.com. Thank you for watching my video and have a great day.